Is the last day on your side?
Yes, my lords.
Last day on your side.
We have accordingly arranged.
Yes, sir, that's what.
I don't know how long.
No, we don't know. We had to, from day one, we have said that 4 days this side, 4 days this side. And we have been telling the learned attorney as well as SG that the timelines have to be followed. No accommodation. You redistribute the time amongst yourself if you so desire. Yes, proceed.
Please. My lords, very briefly, I just recap. I was concluding my arguments on the interpretation of.
You are already concluding.
Yes, on Article 200, my lords. On Article 200. Just very briefly, I'll recap that. And then go on to the next point. I had respectfully submitted before your lordships.
So you stopped at 3 options.
Yes, yes. So I said that there are 3 clear options in the main part, which talk about shall declare, and each has a finality or a consequence attached to it. Withhold of assent means the bill falls. Assent means it becomes a legislation, and reservation for the president means it goes for the president for his assent. The proviso is more in the nature of a preliminary option or a consultative process.
You already argued.
Very sensitive to it. The words at the end of it, which are shall not withhold assent, have been sought to be argued to mean that it is an adjunct to withholding assent, which it is not.
They have not yet started the argument.
No, my lords, even in the ultimately, my lord, somewhere or the other, what was argued in the Tamil Nadu matter comes in. And that is why I'm just saying this, that one of the arguments forwarded was that since the last line of the proviso says shall not withhold assent, it necessarily means that the proviso is an adjunct to withholding shall declare and withhold assent. As I respectfully submitted that neither the textual context indicates it. The judgments clearly say shall fall. And unless can surely, even by the ordinary dictionary meaning as used in those judgments, never be meant to mean that if you withhold assent, it must be sent to the assembly. Unless can never mean that. Unless is a consequence that it shall fall through, unless of course it is sent, where then it's deliberated again. That was as far as 200 is concerned. My next argument, my lords, for your lordship's kind consideration and the historical significance I had shown, your lordship said there's no need to go into it because there are judgments on the point. Returning was a distinct option given earlier from the 1919 Act right through. Return was a distinct option. 3 in the main part and proviso. There it was in the main part in the 1919 Act, then it evolved and became a proviso. But it was always a distinct option given therein, my lords. The second point for your lordship's kind consideration, my lords, is that does discretion exist in Article 200 and 201 or not? My lords, your lordship's repeated judgments on the points have said that this decision will be made irrespective of any advice from the Council of Ministers, and the exercise of this discretion, the governor must discharge his duties to the best of his judgment, is what Shamsher Singh says, and followed then in Navam Rebia and B.K. Pavitra. It was again sought to be argued that discretion is completely bound and there is no independent discretion by the aid and advice. That was specifically rejected, and this is what was said. Now, my lords, please have Article 167 of the Constitution for a minute.
$167.
167. it says, it shall be the duty of the chief minister of each state, and please have B, to furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for. The parameteria provision for the president, my lords, is Article 78. The reason I'm citing this, my lords, is that even with regard to Article 167, which in the draft constitution was Article 147, it was sought to be argued that what is the need for information to be given to the governor? For a proposed legislation, why does governor need information at all from the ministry? Why is the chief minister or the prime minister? The words in 78 are prime minister. Why is the prime minister or the chief minister duty bound to give information to the governor? Because after all, he just has to give his assent. And Dr. Ambedkar, my lords, there specifically said that in fact, the governor's duty, and as part of his duty, he must get this information because it is his duty to advise, to warn, to suggest alternatives, to suggest reconsideration is part of his duty. And he has to be given that information, because if you do not give this information, what is the governor there for? That's what Dr. Ambedkar said. Because he ultimately is not a representative of a political party, but represents the people of the state. As the president, as the highest constitutional authority in the country, represents the people. And Dr. Ambedkar went on to say that otherwise he would be an absolutely unnecessary functionary, no good at all. And then said he's not a representative of the party, he's the representative of the people.
It is a vital link between the state government and the central government.
Very grateful, very grateful. And my lords, why I'm citing this example is that the reason information on proposed legislations, there are memorandums in existence where information, when a bill goes to the president or the governor, memorandums on information is asked from ministries on center state implications, on repugnancy, on issues of constitutional concerns. And after this information is exchanged, an independent judgment, an application of mind takes place. And that is why the constitution benches say, irrespective of the aid and advice of the Council of Ministers. That's the point I'm seeking to make for your lordship's kind consideration. In fact, my lords, in B.K. Pavitra's case,
According to you, even if second time also the Council of Ministers reiterates the bill, still the governor has a discretion not to give access to it.
no, my lords, if the assembly reiterates a legislation, the constitution is very clear. Then after that, he can either give an assent or send it to the president. He shall not withhold assent. I'm not saying that he can still withhold assent, because that would be in the teeth of what the constitution says. All that I'm saying is that the exercise of discretion by the president or the governor, as far as this issue is concerned, involves an independent exercise of opinion and judgment. As far as shall withhold assent is concerned, as far as shall assent is concerned, as far as shall declare that it is being reserved to be sent to the president. It is his independent exercise is all that I'm saying. I'm not for a minute suggesting, my lords, that if he sends it for reconsideration as the fourth option, as a part of a consultative process, because ultimately, my lords, the governor under 168 is also part of the legislature. And your lordship has said that he is part of the legislative component, is what your lordship said in next. So as part of that legislative procedure and component, as part of it, if he sends it back with suggestions, with considerations, as I respectfully submitted on the last date, there could be cases where he's willing to give assent because he feels some things need to be tweaked. It could be cases he feels before it's sent to the president, certain things need to be addressed. So that is part of that consultative process that he sends it back to. But yes, of course, after that, if the legislature in its wisdom reiterates it in whatever form, his right to withhold goes. But his right to withhold in the main part is an independent exercise of his discretion. And the consequence of it is contained in the constitutional bench judgments to say that it shall fall. That is what I was saying. The second argument,
It's already
Yes, so the
argued
sec-
by the learned solicitor.
yes, so the second argument that I'm making for your lordship's kind consideration is this independent exercise of judgment and discretion. As is borne out by these judgments, this is his judgment which matters. In fact, my lords, in B.K. Pavitra's case, an issue arose that when the governor refers a matter for consideration of the president, should there be grounds on which he can refer it? My lords, this court answered it by saying that the framers of the constitution deliberately and carefully eschewed defining the circumstances. You can't define circumstances under which a governor refers to the president. There are issues and issues of constitutional concerns, complexities which will arise. And you can't put them in a straitjacket formula. That will have to be left to the wisdom of the governor. And that's for him to define and decide. And they said that the very nature of conferment of power cannot be confined to specific categories were the words used by the Supreme Court. That's the very nature of conferment of powers that is granted there. So you can't say this will be in this straitjacket formula, only then we'll do it. That has to be left to his wide discretion, which is vested. Now, my lords, as far as the issue of discretion is concerned, my lords, as my lords have also pointed out, under Article 163, one is by and under the Constitution. Then there is 163(2). And your lordships in any number of judgments have said that it could be explicit or it could be implicit, depending on the facts of a case. For instance, my lords, under Article 174, normally, my lords, as held in Shivraj Chauhan's case and other judgments, a house is summoned or a session is summoned on the aid and advice of the ministers. Yet there can be a situation where the governor is of the view that the council of ministers or the government has lost the confidence of the house. And in that case, he's not going to wait. The council of ministers, which has lost the confidence of the house, is going to suggest there should be a floor test. That's an independent view in discretion that he exercises under 174. To have a floor test or a summoning the house to prove your majority on the floor of the house. All that I'm saying is there are any number of instances where, my lords, the discretion has been vested in the governor or the president, whether explicitly or implicitly. My next submission, my lords, for your lordship's kind consideration is on the issue of timelines. In Purushothaman Nambudri, the judgment which the learned solicitor had also cited, it has been clearly held.
Which judgment?
My lords, Purushothaman Nambudri, just get the citation.
Purushothaman.
Yes.
Yes.
My lords, that was 1961 SCC Online Supreme Court 361, Volume 3 of the compilation, the judgment of a constitution bench. The issue was also, my lords, does a bill lapse with the assembly, with the life of an assembly? They said no. Even when life of an assembly comes to an end, for the reason that there is no timeline provided.
That the learned solicitor has already.
Yes, so I said so, my lord. The learned solicitor pointed out there is no timeline. Where, in fact, my lord, the timeline requires to be provided. The timeline in the Constitution is categorically provided therein.
That chart also learned solicitor.
Yes. So, for instance, under 201, there is a time period given.
You may argue what is not argued.
Very well, very well, very well, my lords. So, my lords, as far as timelines are concerned, my lords, our respectful submission for your lordship's kind consideration is that, again, as far as those memorandums, etc., are concerned, where information from ministries is asked for, memorandums are considered, etc., it is impossible to say that within this timeline, the governor or the president must decide. Because there will be all kinds of procedural and substantial complexities. There will be issues, there will be a back and forth.
That is already argued.
Yes. Next point for your
at length.
At length. Next point for your lordship's kind consideration. My lords, your lordships have time and again on the issue of judicial review said there is, and on this I'll devote some time, my lords, that
Scope of judicial review.
scope of judicial review.
by considering the discretion exercised by the governor.
That's right. That's right. Including the issue, my lords, which my lords flagged to me, that suppose there's a constitutional vacuum. Your lords are kind enough to point that's a concern. I'll deal with that. My lords, there is no doubt that in any number of judgments, your lordships have held that the power of judicial review is implicit in a written constitution unless expressly excluded. There's no doubt about it. It is written in for every power vested under every provision. The power of judicial review is there. But your lordships have also consciously, my lords, in AK call downwards in judgments have held that as a facet of judicial review is justiciability. And there is a difference between judicial review and justiciability of a particular action. And your lordships have also held.
That is also argued by the learned.
Malas, I need to argue something.
No, you can argue.
I'm just developing on that.
We have been requesting, please don't
Yes,
take
yes.
arguments which are already.
I'll just develop and just leave it. The reason.
Otherwise, Mr. Jetmanani will never get a chance.
Yes, no, Malas,
If all of you are going to again argue what has been argued by the solicitor.
No, my lords, we won't. The reason I'm saying so is, my lords, the reason I'm saying so is that the action of judicial review is always tested on the touchstone of the Constitution. Now, as far as justiciable, manageable standards are concerned, my lords, your lordship says that where there exists none, the action is not susceptible to judicial process. That's all that I'm saying in these cases. Now, why I'm...
Please repeat your argument.
My lords, I am saying that where there are no justiciable standards on a particular action,
Where there are no justiciable standards.
for a certain action,
Justiciable.
manageable, justiciable, judicially manageable standards is what AK call refers to.
Really manageable.
Judicially manageable standards. Where there are no judicially manageable standards to judge an action, it will not be susceptible to judicial process. So within judicial review, although it's inbuilt into the Constitution under every provision, there will be actions which are non-justiciable. Because, as the Supreme Court says, there are no judicially manageable standards for them. So no one is saying that the power of judicial review is not implicit. The power of judicial review is implicit in every provision. But there will be certain powers, there will be certain discretions vested, which do not have justiciability aligned to them, because they're incapable of being adjudicated upon. And I'll tell you, lordships, I'll give you lordships examples as far as this exercise of power are concerned. Any judicially manageable standard requires an objective, ascertainable criteria. Now, effectively, my lords, in exercise of all these decisions, there is a certain operational and substantial complexity. There are considerations of stakeholders. There are interstate relations. There are consultations with ministries. There are public interests which are involved. There are constitutional conventions and not just basic fixed rules involved. And that is why I say, my lords, this cannot be compared to the exercise of power under Article 356, and I'll just come to that. This is so generous in itself as far as the exercise of power by the governor and the president is concerned. Under 356, my lords, for instance, when your lordships in Bomai and other judgments dealt with, there is a failure of a constitutional machinery. There is either a report from the governor or otherwise, and a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. That the court felt in the given circumstances was something subject to judicial review, and of course, if arbitrariness or malefides are shown therein. All that I'm saying is this form of judgment and exercise of opinion of the governor and president by its very nature is not justiciable. Now, the question that Your lordship is supposed to be on the last date.
Discretion under section 356.
Please?
If the discretion exercised by the governor under 356
Yes,
is justiciable,
yes.
then why not a discretion?
Yes, my lord, that's exactly what I'm answering.
201.
That there are contours where it is justiciable, breakdown of machinery, failure, report of a governor, the government cannot carry on any longer. All that I said was there are a lot of substantial and constitutional complexities when a decision is made under 200 and 201. Stakeholders, interstate relations, constitutional concerns, constitutional conventions, and then a judgment in his wisdom is made on these parts. And that is why your lordship said that even an assent given by the president is non-justiciable. Your lordships categorically held that neither the legality or the deliberation as far as the assent by the president is concerned is justiciable. In Kaiser Hind and other judgments, your lordships have categorically